prevent domestic abuse, prevent emotional abuse of elderly or at-risk adult, prevent sexual violence, prevent stalking. My office usually deals with protection orders related to violence, so often intimate partner violence, but certainly there's also like the neighbor dispute, and sort of just like people who've never been romantically involved or not leaving each other alone. So the court does do those as well, but there's a little bit different process for those, and they require mediation. So if you have a protection order and you're on either side of it, and it's not an intimate partner, then they'll order you to do mediation at what's called the Neighborhood Justice Center, and basically try and figure it out yourselves before they'll let you have any hearing about a permanent protection order.
Okay, question.
Yeah.
In the process of getting all the paperwork to actually do one of these, I guess my sister's ex-wife, or soon to be ex-wife, she's been told to stay away from us multiple times and has gone on to call protective services and the police on me because I leave my 10-year-old at home while I have to go to work.
Okay.
They still gonna go make me go through mediation for that?
So let me go through and see if you still have questions when I kind of go through like the overview. But yeah, that wouldn't be an intimate partner, so it would require mediation. Yeah, but let's go through and see if maybe some of the answers are on the slides. We'll see. You don't have to have any police report, any criminal investigation, or any criminal charges. It oftentimes the trial is really just based on people's testimony and the judge deciding who's credible. So there doesn't have to be any corresponding case at all.
And the individual has to be served, right?
Yep.
Yes.
Yep.
Okay.
Yep, and I'll talk about that too. So venue, where can you file? Very different from a criminal case or even a divorce case, which are really specific to where people live. A protection order case can be filed wherever anything happened, or wherever somebody lives, or wherever they're employed. So really, the legislators tried to make it as easy as possible to file wherever you are, and try to get that safety. Because if you had to file where the thing happened, oftentimes that would take people back to a risky place, and so they try to avoid that. And this is way more info than I'm sure you want, but I think it's important to know the why, whether you're trying to obtain a protection order or trying to get out of one against you. The why is really important because it's really like kind of what the judge is thinking. So if your case isn't aligned with the intention of the law, then it, maybe doesn't make sense. Or if it's like exactly in line with the intention of the law, perhaps it does make sense. But I would say the thing that the court relies on a lot is this underlying part. So basically, they're trying to prevent things that continue to control a victim and make them more likely to return. So things that are sort of meant to control, retaliate, prevent them from having their basic needs met, like maybe like a classic example is like no access to money, taking their phone, locking them in a room, taking their keys, things like that, like again and again. Protection orders aren't meant for like, this one thing happened once and it was really crappy and I'm mad about it. They're meant for like, I am not safe from this person without this protection order and they're gonna keep being in my life. So, let's see, and then,
Am I the only one that, like, is thinking, okay, you don't have to go back to the place that it happened because high risk to injury, but they want you to go through mediation with the very same person? Like, how does
well,
that make
not
sense?
if there's domestic abuse or intimate partner violence, they don't require mediation for that. And sometimes the court may deem it not appropriate if there was maybe like physical violence or something like that. But yeah, just sort of the process. I think it's because a lot of those cases that aren't intimate partner or aren't like domestic related, they often lose at trial. And I'll go through like the burden that you have to prove and all of that.
Well, like, I've run into a lot of them are, they work together. Or work at the same business or in the same apartment, so they.
Sorry.
The people that are fighting each other.
Oh,
basically,
yeah. Yeah, they work, oh, like,
they
they're
work
employed together, yeah.
Or like they live in the same apartment complex, it's easier just to
Yeah.
sit down and try to talk something out
Yeah.
versus like
That's exactly right.
making somebody switch job.
Yeah, a lot of them are neighbors, like, and they own their houses, like, they're not gonna, make one of the moves, they're gonna try and figure out something that will work. Yeah, and I'm not gonna go through all of this intention, but I would suggest you read it if you are going through a protection order, because I think it can be really helpful as you're like preparing for hearing to either, try and get a protection order, try and get one dismissed. So the process for a protection order, they are, what the court refers to as highest priority in the courthouse. They have the shortest turnaround time. They have to be heard within 14 days once one is put in place. So the first step is filing the initial documents, and then you have an ex parte hearing, which means the other party's not there. And then if it's granted, you serve the respondent, and then they give you a return date where you come back. They schedule that return date as a permanent hearing. It almost never gets to hearing on that day. They do it by priority, so a lot of cases have been continued a bunch of times, and those ones are gonna go to hearing. And also, in the statute, and I'll go through this, in the statute, either party can ask for a continuance, for one continuance. So almost always, one party or the other are gonna ask for that continuance on that first court date. Often the court will also continue you. And I'll go through that a little bit more, but I really encourage people to, sort of like, strategize a little, wait and see if the court's gonna continue your case or if the other party wants a continuance before you offer up your continuance, because you really do just get that one. So if you don't need to use it, don't use it. Do you have a question?
No, I was gonna say probably the most important part is when you file your initial documents.
Yeah.
Anything you wanna talk about with
Has
the
to be in
judge
there.
has to be.
Yeah,
on
that's a
that
really
document.
good point. Yeah, so the initial documents, there's the complaint, the affidavit, the incident checklist, and the info sheet. The incident checklist is not required, but I encourage everyone to fill it out. It helps expand on, like you said, like, the course required, they're not required by the statute, but here in El Paso County, they're very firm about staying in the four corners of the complaint, they call it, so only caring about things that you actually brought up in there. So this instant checklist allows you to, and I have a picture of it, in a minute, it allows you to put dates and times and locations of everything and in sort of every category of abuse or harassment or stalking or whatnot. So you have to fill out the verified complaint. They're on the court website. It really just requires basic information. I think a lot of people are really intimidated by court forms. They think there's like legal things they need to know, but most of the forms are just like, who are you, who are they, what happened, and that's kind of it. Make sure you list any minors as protected parties. One caution is if the minor child is a shared child with the other party, they're going to be removed at that upcoming court hearing. So just be aware of that, and the court will explain that to you. And then the document asks for the most recent, the most serious, and other. And again, if you just fill in like the two little lines, you may not have enough for your hearing. There's no restriction on like adding a page on the back, typing 50 pages, I think that would be kind of annoying for the judge, but maybe like one page addendum or something like that. You can also ask for like specific restrictions. A lot of people just put their home address. You can put your school, you can put where your kids go to school, you can put your work, and you can also clarify if you need some kind of contact. Sometimes people are quick to file a protection order against someone, and then they realize, oh crap, I actually need to know, that they're paying the mortgage, or that they're doing this, or this, I don't know, taxes or something. So just be thoughtful about, like, if you need an exception, make sure it's in there. It doesn't like change your chances of getting success in the long run. And then verified just means that you confirm that it's in fact true. So you have to like swear that everything you put in there is true. And then the case information sheet is like literally just basic. It asks things about the respondent, like how tall are they, how much do they weigh, eye color, hair color, things like that. And then an affidavit regarding the children. And that's so that the court can kind of look in their system and see if there's other documents that would be controlling the contact with the kids. And then again, incident checklist is optional. And here's what it looks like. So it allows you to add all of these examples. You don't have to fill it out, and if you do fill it out, you don't have to fill out every box, but, I've found that sometimes people will say, a couple of things on the complaint, and then when they start going through this incident checklist, they realize things that maybe were tucked away from trauma, or maybe they forgot about, or maybe they didn't think were important. So just make sure you go through that, at least, to jog your memory, but I would encourage you to file it as well. And then you file them. There's no fee if it's, domestic abuse related, intimate partner violence related. There is a fee, if it's like a neighbor dispute type thing, like a harassment neighbor, probably your scenario, you probably have a fee. I think it's like $100. I never do them, so I'm not really sure.
So it's 150.
150, okay.
Yes, but also if you have, if you're on public assistance,
They
most of the time they don't,
Yeah, they should waive
they
the
have
fee.
a waiver that.
Yeah, and then the self-help desk, is really helpful, or should be really helpful, I hope, for these forms. I will say, one of the Sherlocks, so there's 3 Sherlocks that work at the self-help desk at the courthouse. One of them just retired at the end of December, so they're a little short-staffed right now, but hopefully they'll still be able to help. And if you file your protection order by 9:30 a.m., then the judge hears it that same morning. They will allow you to leave and be on WebEx if you can't stick around all morning. It does take a few hours. Some mornings there's like 50 people there getting protection orders. Some mornings there's like 5 or 10, so it really kind of depends on luck.
If it's DV related and you communicate with Tessa has a worker at
Oh,
the
yes.
courthouse that you can meet at like 8 o'clock in the morning and they'll help walk you through.
Yeah.
But like she was saying, you have to really pay attention to what you're putting in there, because if you leave something out with like paying a rent or
Yep.
anything like that, it won't be on the
No, but they'll make you, they'll do a continuance and make you go file an addendum.
Yeah, and the Tessa, note is important. I should add that to my, presentation. But they do only help you if you qualify for Tessa. So most of the time, that would be the case, but sometimes they like have a conflict, or maybe you're, for some reason or another, you don't qualify. And then they'll send you to the self-help desk. And then the ex parte hearings are heard, Division O, same day or next day, sometimes busy again. If denied, they'll usually tell you why. So this is kind of different from other courtrooms where like, if you lose, they're just like, kind of good luck. In the protection orders, especially if they think that maybe maybe they're a little concerned about you, and your safety, they're gonna tell you, I can't grant this today because you didn't give me enough detail, or you didn't share an event in the last year, or whatever their reason is that they decided that they're gonna deny it, they'll tell you. And if they don't right away, you could ask, like, is there anything I could do to make it more thorough? Things like that. If it's granted, you have to have the other party served. So service can be made by anyone over 18 who's not a party. But I always just tell people to use the sheriff for protection orders because they don't charge if it is violence related. So have the sheriff serve. If it's not violence related, I think it's like $35 or $40.
25.
25. Wow, okay.
I went a couple of years and it was 35, so.
I think it depends on where the person lives, because they do like 1 fee and then like a mileage fee if they're outside of like 5 miles. And then a lot of people are like, well, I'll just have my, my new boyfriend do it, or my neighbor, or whatever, and it kind of like adds more conflict. So I really encourage folks to use the sheriff. And if you have a known address, they're happy to do it. Also, sometimes, folks are in jail when you're trying to get a protection order against them, and then it's really easy to have the sheriff serve them. So, and then if the sheriff served them, they also file the return of service. Whereas if you have someone else serve them, then you have to file the return of service, and if you don't file the return of service, then you can't go forward with your hearing. And then if you have issues serving, the court does have to give you reasonable continuances to support that. So as long as you're showing proof of attempts, like you maybe have like an affidavit from someone where they're like, maybe the sheriff's like, I went to the house, they knocked 3 times, their car was there, no one answered the door, they turned off the lights, whatever, like clearly they're avoiding service, then you can ask the court for another continuance and they'll grant it. And so at that return date, you're not the only one. So, like I said, and I try to just reiterate this because people are just always surprised, like, well, my protection order hearing was set for today and it didn't happen. Like, yeah, and it might not happen next time either. It's like really backed up, I don't know why. It's actually better now with this
We're not
judge.
shut down that happened. 'Cause
Yeah,
I
oh,
was in
okay.
the middle of doing one then.
Okay.
You'd sit there probably an hour past the time that you were supposed to be there, and the judge would say, come back this date.
Yeah, and they used to do like if more than one, person wanted to have their hearing that day, they would find another judge in the courthouse to just jump in and do it for an hour. But they don't really do that anymore, because I don't think any of the other judges are free. So anyway, again, you each have the chance to ask for continuance. You don't have to have like some magnificent excuse for why you need a continuance. It can be anything. It can be like, I'm really overwhelmed by all this, I wanna get my papers organized. It can be I'm trying to get a lawyer. It could be I'm going out of town next weekend. It doesn't matter. The statute requires that the court gives you a continuance. If everyone's ready and you're the priority case, then your hearing does go forward. Make sure you're not late. They will call the cases right on time. And especially if you're the respondent on a protection order, if you're late, they may have already issued a permanent protection order against you. And you can't just go in and say, sorry, there was traffic, because it's already done and the judge will not care. You can, if you're like running late and have a real live situation, like a car crash or something, then you can like contact the court, contact the clerk afterward, let them know, probably provide some proof. Like they're not like, monsters, but they also like aren't just granting people continuances because they didn't show up at time. If you're the petitioner, respondent doesn't show up, you win automatically. You don't have to provide any proof. You don't have to testify. The judge will just say, do you want to make your protection order permanent? And you say yes, and the judge will say, great, and they'll grant it. The end. And then again, they're heard on the third floor of the South Tower. Some people ask like really specific questions about the courtroom, so I started including petitioner sits on the left, respondent sits on the right. There's a judge and a clerk, and then all the other people getting protection orders. So it's definitely not a scenario where it's going to be like a private conversation with the court. All of your business and your case is going to be shared with all of the people in the room. What if you do have to go to hearing? How do you prepare? So the burden of proof is preponderance of evidence. So that means more likely than not. So basically more than 50%. So if the judge can't decide that, that probably didn't happen, then they must decide that it probably did happen. And these are the two prongs. So you have to prove that the respondent did in fact commit the acts constituting grounds for getting a protection order. So the things you wrote in your complaint, they have to decide that they're true. But they actually only have to make a finding that one of the things are true. So it doesn't need to be like 400 things or a lifetime of things. It just can be one act for that first prong. But then the second prong is where most people lose. And that is, unless restrained, they will continue to commit such acts, I should say, designed to intimidate or retaliate against a protected person. And so that, usually you have to show some sort of habit, right? So like, I tried to leave 5 years ago and they followed me, or I turned my phone off and I got a new number and now they're still calling me somehow and I never even gave them this number and they're sending me these messages and harassing me, things like that. Sort of like, I've set a boundary, they didn't follow it. Or it's really great, not great, but it's really great evidence if they have like an actual protection order violation while your protection order is open, because then that second prong kind of proved itself. Like there already was a protection order and they violated it, so why wouldn't they violate it again? Yeah, so that's the part where folks usually struggle. And sometimes if you feel like you're not super confident about proving that second part, that's where you might want to consider some of the other options, which are a temporary agreement for a protection order for up to a year. So people could do like 3 months, 6 months, 1 year, and just agree. And then if that happens, you don't have to provide any evidence, you don't have to testify. And then at the end of that year, as long as the respondent hasn't violated, then it just gets automatically dismissed, goes off the record, like nothing else ever comes of it. So,
definitely wanna bring out the dismissal, that you want it dismissed without prejudice, that way if there is an incident, you can still use all of the evidence from that one.
absolutely right. If people have, sometimes if people, especially if they have an attorney, they won't agree to the 1 year if you don't agree to dismiss it with prejudice afterward, which means that you can't file on those same allegations. But yes, if you're ever gonna agree to dismiss it, you wanna agree to dismiss it with what's called without prejudice. Well, the judge will explain all that stuff. He actually, has created a bunch of language. If yours was like COVID time, it may have been the old judge. This new judge has been on the bench for like almost 2 years. He's kind of shifted things. He provides like just a lot of sort of guidance for the parties on the options and the next steps and the cautions and things like that. And then, so general tips for hearings. The court will give you a little pamphlet of the Colorado Rules of Evidence. You don't have to be, like Matlock or anything, but you have to kind of know the basics of like what you can put in and what you can't put in. Make sure you practice ahead of time, because you are gonna be on a clock, on a timer. Usually get about 30 minutes to prove your side. So a lot of people will say
It was
like,
actually 15 minutes for each side this last time.
oh, wow, okay. Yeah, yeah, and I know people can ask for more time if they think they need it, but the judge has to agree that they need it. So a lot of people who are like, I'll have everyone I know just come testify that like Steve is a crappy guy. That's not gonna help you. Like what you really need to do is just have the evidence that proves the things that you put in your complaint. Make sure you bring copies of everything, one for the other party, one for the judge. And make sure you have one for yourself, which I refer to. A lot of people forget that. Wow, I'm so alert. Supposed to really be into my presentation. And then know specific dates and times. Be really organized. Tell the judge your story so they can imagine it. So your story and what happened to you and how you felt and if you were fearful, things like that are gonna be so much better evidence than like, well, he's a jerk and this is why, or did you know one time he did this to his other kid or whatever. Like insults, not gonna help you. In a protection order, your story and how you felt and any fear, any anxiety you're having about it, lack of sleep, things like that, that's kind of where you're gonna get a little more credibility with the court. Focus on facts and experiences again, and then, yeah, there are strict time limits. Sometimes the court will say like, do you wanna do a quick opening or a quick closing, kind of like tell me a summary, but not super often, especially when you're backed up. Some examples of evidence, telling your story, cross-examining them on their story. So you actually, it's a weird scenario, right? Because you're filing this thing saying, I want this person to never be in my life again. Meanwhile, in this hearing, you have to talk to them, interact with them, have them testify. They get to ask you questions, you get to ask them questions. The court is really good about shutting it down if those questions are inappropriate or not relevant. But either way, it can cause a whole lot of trauma and anxiety when you are saying, I'm afraid of this person, or I get, like I want to puke, or I almost pass out when I see this person because I'm so worked up about what happened. And then they're like, okay, well, cool, now ask them questions. So it's just a really complex process. But other witnesses, you're only going to want to have other witnesses if they saw or heard what happened. A lot of times, a good witness is someone you called in that moment, like something really traumatic happened, and you called someone to be like, oh my God, what do I do? So whoever that person is for you or was for you in that incident. Same with like if you're the respondent and you're like defending a protection order, there may be someone that you kind of retold your story to right after it happened, and that could be a good person to sort of back up your version of the story. So that's helpful. And then videos are great, but make sure you sort of have the tech figured out. If you're like, here, look at this thing on my phone, not in a million years is that going to come in court. You have to bring a device to play your video. You also have to bring thumb drives with your video on it. And make sure that your whatever device you have has sound, and make sure it like projects. Sometimes people will bring like a Bluetooth speaker, If they have like audio recordings, then you can connect that to your phone and sort of project that for the court. But if it's like a video where you need to look at it, just make sure you've got a way to play it that's big enough for the court to see, and then also that it has sound.
So if you can't find the person and then they never get served, like how does that work?
Then it gets dismissed without prejudice, and then you can file again anytime that you, maybe they get locked up or something, or maybe they reach out, then you can refile, with those same exact document, basically, just with a new date, and have them served.
Okay.
But yeah, it's not like like in a divorce or custody case, you can go forward with the case by like publication or doing all these other options, even if the party's not participating. You can't do that in a protection order. You have to have personal service.
Okay.
And then documents, between the parties, text messages, things like that, emails, but not, like emails with a third party, unless that third party's testifying. Like you could bring in things that you said to a third party, but things that the third party said to you in a message, like, this happens sometimes where like, somebody else who was maybe a victim to something that you're alleging that the respondent did to you, reaches out to you and they're like, oh man, that happened to me too, and this is what happened, and blah, 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 and so people are like, oh, I can use that. Well, you can't use that unless you have that person come in and say that. And then, so care and control is what the court can do if there are joint children. They can enter orders regarding, parenting time, decision-making, and, like, they can do parenting time, but really parties kind of have to agree or come up with something. If the parties are like just a world apart, the court's not gonna, without having like the best interest hearing that a court would be required to have to figure out what's best for parenting time, they're not gonna implement some sort of like 50-50 or something. But they may like if people already have maybe some sort of agreed parenting time arrangement, they'll put in clarifications like exchanges at the courthouse and communication only on an app or an email or something like that. The court can't require you to file a custody case, because some people, for 1,000 reasons, don't want to file a custody case. Maybe they've got things worked out that they want, or maybe, who knows, millions of reasons. But either way, the court can't require it. The judges used to tell people to do it. They would be like, well, I'm not gonna touch that. You guys need to file for custody.
Okay.
But the legislation, was updated at the end of last year, and it explicitly says, last year, 2024, now it explicitly says the court they cannot make you file a case. So those are just some things to
All
know.
they did was exchanges of child had to be at a police station in the lobby.
Okay, yeah.
And they told me to file if I wanted to, something at the court, since we had an open divorce as well.
Oh, yeah, and if one is open,
There was never a parental plan in place, so when I filed the temporary custody with the court, it got denied because they can't amend anything that never existed.
Okay.
So that was.
So you had to have a
big
hearing?
blow. No, didn't even go to a hearing.
No, okay. Yeah, I don't know, it gets really tricky when there's an open custody and divorce case pending, or even just a divorce case pending when there aren't kids. But there's any like orders in that case. And then there's orders in the protection order case, and sometimes there's also a criminal case, like a mandatory restraining order or something. And then when those are all overlapping, often the judges aren't great at making them consistent. So then parties are like, I have no idea what the rules even are. Yeah, so it's really hard to navigate. And then as far as contact, I always encourage people, even if maybe you don't have like the most severe high conflict, but especially if you do, communicate however you feel most comfortable, but make sure you put things in writing. Make sure that you are documenting things. So if maybe like sometimes one person will not be interested in putting things in writing, and they'll be like, no, I'll talk to you at your house. Because they don't want any of that stuff written down, and they want to be able to say all the worst things to you to your face. After those conversations, if you're not in a position to like record them or something like that, I encourage folks, and sometimes this increases the conflict, but Hopefully you've got sort of the protections in place. But I encourage folks to send a follow-up. We just talked in my house, you called me this name, you made this threat, whatever it is, put it in there. And then they're either gonna say, no, they're not, no, I didn't, or they're gonna get really mad and say more really terrible things in writing. So I encourage people to put things in writing, even if they can't ahead of time. And then exchanges, be thoughtful about logistics. A lot of times the court is quick to use the police station, but sometimes it's fine for like babies, whatever. I think for older kids it's weird, especially if the kids have ever been involved in any trauma for this like family. It's not gonna make them feel safe, it's not gonna make them feel normal. So I like to encourage maybe like the library, they have security, they've got metal detectors, they've got people around, it totally would be fine. Also there's like a little play area at all the libraries in town, or computers if kids are older. And then, where else? I also like the Starbucks inside of Target. I personally don't love Starbucks, but just like physically to be there. Because then if like the other person, maybe sometimes parties are late, and sometimes they don't give you notice. So at least if you're somewhere like that, you can like grab some milk or whatever else you need to do for your own life. And sometimes that's helpful. And then, safety with exchanges, if you feel like it needs to be somewhere with surveillance, again, make sure you're somewhere where there's people around, where there's security if you need it. Sometimes if maybe someone doesn't act their best at exchanges, but you don't feel like they're gonna like punch you in the face or kill you or something like that. Sometimes I like the fire station because those are like really fun places for kids to go, and they're usually like fire truck, firemen. So sometimes that's a fun place to exchange kids, and it's like not super traumatizing. And sometimes when I tell people like the library, they'll say, well, my kid's too loud, or I'll say the Target, they'll be like, no, because then my kid will like throw a fit because they want to buy everything. So then sometimes I end up at the fire station. But anything that works for your family. If you do, and sort of this is like separate, but if there ever is a custody situation, really the best thing to do is school drop off and school pickup, and you never see each other's face if you don't want to. So, and then in the summer you figure out some public place for that. But there are visitation centers, there's supervisors, there's therapists, if there's that sort of level of supervision needed. But hopefully if there is, it's temporary and there's some sort of like interventions in place to help reduce any risk that's being alleged. That's kind of the same, just with a few more examples. Well, I kind of forgot the mall, which are pretty empty these days, but a mall or a park, depending on the weather, are also really great exchange places. Because you can kind of hang out too, or like kind of nearby. So what if you lose your permanent protection order hearing? It will get so if you have a hearing and you lose, it will get dismissed with prejudice. So you cannot file again on those same allegations. But it will get dismissed without prejudice, which means you can file again with the same facts. If the judge denies the initial one, or if you can't find the other party to get them served, or if you just like couldn't make it on time and you're the petitioner and the court dismissed the case. And then it will be dismissed with prejudice if you have a hearing and the court doesn't rule in your favor. The court doesn't have the option in the statute of ordering a 6-month protection order or 1-year protection order. That's only up to the parties to agree on. Once it goes to a hearing, it's permanent or never. It's like, yes, absolutely, you need this forever, or it's dismissed today. Those are the only options.
And what if, let's say you go to you get the initial one, and then you go to the hearing, and let's say they continue it, but then you go and you do, what's that thing, like a motion to dismiss it or to like end the protection order?
Oh, sure. You're the petitioner and you don't need it anymore?
Right.
Yeah.
So if you make that motion, are you able to go back and redo it again, or is that?
Only if you put in a motion without prejudice.
Yeah. But if you're the petitioner and you don't need the protection order, you can just not show up. But if you're the respondent, you have to show up.
Right.
I mean, the petitioner, like, you have to show up too, and if you don't show up, it will get dismissed. But if you show up and the respondent doesn't show up, then you'll get a permanent protection order.
So if they make the motion to dismiss it before there's even that court date again, then that's it? You can't refile it ever
You
again?
can, yes.
You can.
Yes, you can. Yeah, if, yes. Yeah. if
How does the
petitioner-
judge look at that though?
I don't think they really care. A lot of times the respondent will try to use it as evidence. But I think the court, I'd say especially in this courtroom, is pretty educated on like the cycle of violence and sort of like care and control, or like power and control, and just sort of how things go up and down and things change. So I don't think the court, like, they wouldn't use it against you later on. Not that like the other party wouldn't try to use it against you, like, well, you weren't scared last month when you dismissed the protection order. You know, but I think honestly, I think it kind of works in people's favor, because it kind of helps show that second prong I was talking about earlier. If they file one and then they dismiss it, because like maybe the person was leaving them alone, right? But then you're filing it again, which means they're not leaving you alone, which shows that pattern that you need to prove for that second prong. And then, okay, this should be the last slide. I don't know why this is in the middle, but the Justice Center, which is down the road, as another resource for protection orders. There's also online tutorials on their website where it talks about like evidence and the different processes. And then there's a self-help desk that you can call. The Brady Bill, if a protection order is based on an act of domestic violence or involved in threat or use of physical force, or attempted use of physical force, then they can no longer possess firearms. This, in my experience, is like the thing that makes people fight protection orders here, because they just care so darn much about their guns.
Not necessarily.
Well, I have noticed people really, really care about guns, and especially with the military, we get a lot of protection orders in military cases, and once that firearm restriction gets in place, their position changes, maybe they lose their job. So it's something to think about, especially like if maybe the respondent has to use a weapon for their career, and their career is your income. Like it's kind of hard to navigate. So that may be a
What
reason.
I've found with this,
Yeah.
the biggest faux pas with this is the fact that you can claim, or the petitioner can claim that, oh, they threatened me with gun, even if the gun was locked up and you were out of state.
Well, you don't have to threaten someone with a gun. You just have to threaten physical force. So it doesn't.
Even if you never did it,
Yeah. Well, it's
this
up to
can
the.
still be enacted. It was enacted on my sister. She
Yeah.
she was out of town, didn't have access to any of them, and would never threaten to hurt anybody. And her ex-wife still said she did.
Okay, yeah, it's up to the judge, I mean, to determine people's credibility and review the evidence, so, you know, every case is gonna, it's like impossible to say how a case is gonna turn out. But, you know, there's also like the appellate process if someone disagrees with the result. And then, so if someone doesn't relinquish their firearms, you fill out the affidavit, that they've relinquished their firearms, they can be arrested. And so that's the end. I feel like, there was another thing I was gonna add, but no, it's not coming to me. So what questions do you guys have, if any?
If someone gets a permanent restraining order, is that on their like background check forever?
Yep, yeah, it sure is. So if somebody's going into like, nursing, teaching, certainly the military, a whole bunch of careers are gonna be affected by it. Even if you're like applying to some sort of school, it's often gonna be flagged. One thing that sometimes people will try and encourage you to do if you have like a divorce case or something, they'll say, well, why don't you just make an agreement that they're not gonna leave each other alone? So just a caution, I don't know if that would apply to any of you, but that's a terrible idea. Because if you agree in your divorce they're gonna leave each other alone. It's not enforceable except through like contempt with a divorce judge, which takes like months, sometimes years. It's not safety. Whereas like if you have a permanent protection order, you call the police, that person gets arrested. They get a criminal case, a brand new criminal case. It's not just like, oh, they get in trouble. They have a brand new criminal case. So like if they're on probation, probably gonna be a violation. It's a really, really big deal. So, and that's why the court does really try hard to only grant those permanent ones, like when they really, really need to. But yeah, it shows up on your record. You can, after 2 years, motion to have it dismissed. So like as the respondent, you can get in, well, the petitioner too, you could go in and ask for it to be dismissed. But often it's the respondent who's wanting it to be off the record and wanting it to be dismissed. There's like a really specific process for that. You have to get a background check for yourself. You have to do, I should probably have a slide for that next time too. You have to do, like show basically why circumstances have changed. Because if it's just like, well, I'm just not about this and it's been 2 years, like the court's not gonna care. But if there has been a change in circumstances, you haven't had any communication, you know, you have to serve the other party with that motion to dismiss it. So, you know, maybe they'll come to court and say, yeah, you know what, we don't even, haven't seen that guy in 2 years, haven't seen, that, you know, like we have a kid, but we got this agreement, exchanges haven't been going fine, whatever, like we don't need all this anymore. So sometimes people will agree. I see that happen a lot with like, a lot of protection orders are like parent-child, like 20-year-old son and dad or mom or whatever, and then they always come back like a few years later. Like, okay, well, you know, we figured it out and we're just going through some stuff and whatever, so. So yeah, you can get it dismissed, especially if you both agree, absolutely, you can get it dismissed. But if you decide, like you were saying, that you wanna do a motion to dismiss it, or you like kind of show up at court and say, you know what, I changed my mind, I think I need to do this, the court's gonna ask you, like, do you feel safe not doing this? Do you feel like you will be in danger if you don't have this protection? Like they'll ask some sort of like extra questions, because there's certainly scenarios where people are forced to go in and dismiss the protection orders, and that it's not an option. So the court kind of hopes that you'll speak up if that's the scenario for you. But I would imagine often people don't. So, yeah, what else? What else did I forget?
If the case involves getting a protection order to protect kids, like in the case of my daughter and my niece, they were assaulted by somebody who was in the home.
Okay.
If he decided he wanted to go and try to get it dropped 2 years later, would he be able to, because he's been, like, there's evidence that he has that.
It's a civil protection order? And he's not in the home anymore? I assume? Okay.
No, he was removed that night.
Okay. Yeah, I mean,
Technically, he's not even, from what I've heard, he's not even alive anymore, but.
okay. Yeah, I mean, he could still motion to have it dismissed, but then the court, like, once he sort of, checks those boxes, does the background check, provides the information, then it's not like he automatically gets it dismissed, then there's a hearing. So the other party still gets to say, like, why they still need it and why they wouldn't be safe without it.
Okay, yeah, because it's been put in place until our kids are 18.
Oh, okay. It has like an expiration on it? And then they have to go get their own, if they want.
Yeah.
That makes sense.
Until they're essentially legally old enough to get their own.
Yeah.
From what I heard, he actually OD'd on fentanyl.
Oh my gosh, I felt like,
So, like a year later, I haven't seen him since, and my friend's dad actually works for the El Paso County Sheriff, so when we told him he went and looked it up, apparently it would.
well then, don't worry about it.
But I was figured, you know, the question that was on the mind when I
Yeah.
asked it.
Last question. Okay, so I know like the protection orders in general are like civil.
Yeah.
So if you say this person choked me half to death or something, obviously that's a criminal offense.
Right.
So if you show these things in court, do like they turn it into a criminal case?
Well, so that's a good question. So ideally,
Yeah.
police are already investigating or the DA is already filing charges. But there are.
If you put that in the restraining order.
No, if you file a police report and talk to the sheriffs. If you just go to civil court, no, absolutely not. The police are not like screening any of that, the DA is not looking at any of that. But if the police are investigating, or if they've already filed charges, criminal charges, they can use every word of testimony and all the evidence that comes in that civil case, in the criminal case. But also, sometimes, like, let's say you've got like a partner and you were like the victim of some violence and the DA did file charges. And then you're like, oh, I want to go get a civil protection order. Sometimes the DA and the victim advocate that you would have would encourage you to not at the moment, especially if you have like a mandatory restraining order currently in your criminal case, because they're worried that, especially when people don't have attorneys in the civil cases, that they'll kind of like muddy up the evidence and make it harder for them to prove their case in the criminal case. So sometimes they say like kind of wait until you get closer to trial, and then maybe file or maybe get some sort of other agreements in place. Because the mandatory restraining order in a criminal case ends whenever that criminal case ends. So whenever the probation term is over or whenever the case is dismissed, that mandatory restraining order goes away. There's no questions about whether or not you feel safe or anything like that. But no, I can't imagine how many more cases the DA would probably file if they screened all of those civil protection order cases.
Like, if they're in jail, they have no contact order put in place until, like, the day after their court date or the day they get out. They'll have no contact order in place, which means they can't contact you. They can't have somebody contact you on their behalf, like a cellmate's mom is not supposed to contact you. One of their friends, like say his mom, his dad, her mom, her dad,
So that's true if there are criminal charges filed, but not just if someone's like arrested. Someone gets arrested and the DA decides to not prosecute, or they don't have enough yet, and so they didn't file charges yet, and that guy gets released. He has no rules whatsoever, just back in the street to do whatever he wants.
Yeah, that's why I said while they are incarcerated, there's usually no contact order.
Oh, well, they're in jail. Yeah, if there's a corresponding criminal case, for sure.
So if nobody's been arrested like on scene in the midst of the craziness, then the DA is kind of like heavy on, they want to make sure that they have evidence like without a doubt, so they know they're not wasting their time on a case that's just they're not gonna win.
Yeah, so they're gonna try and get kind of their ducks in a row before they file, hopefully.
I know.
Yeah, and then also Colorado is a mandatory arrest state, so that means that like if you do call the police while the thing is happening, the court is the sheriffs here are required to arrest one party or the other. That's how a lot of times maybe they don't get it exactly right here in El Paso because they kind of hear different versions and there's other layers, and so so a lot of times there's like maybe the person protecting himself gets the charge, or maybe the person whose mark didn't show up yet on their skin, maybe the other person gets the charge because their mark showed up, or maybe someone has blood and the other person has like injuries that you can't really see. So yeah, sometimes the police don't get it right, is the moral of that story. Yeah, hopefully they do, and hopefully if they don't, there should be like advocates with the police and advocates with the DA, and we've been referred at our office a whole bunch of cases from the public defender's office where they're like, I have this person who is being charged with these like DV cases, and there's no way on this planet that they did that. Possibly were the perpetrator.
Sometimes they'll charge you if like you defended yourself with a knife, and like you have marks all over you, you look like somebody beat the tar out of you, but you weren't bleeding, and the other person was.
Yeah, but sometimes they also will charge both people.
Yeah,
And because crimes are still crimes, so like sometimes you're maybe both gonna be charged, and then they'll have to figure out like at the jury trial like what who's guilty of what. So yeah, I think they're really complicated.
And a lot of these, like, at least half of these things don't even need to happen if people would just learn to walk away from each other.
Yeah.
Yeah, there's a lot of layers though, you know, a lot of
There's
times.
their own interpretation on things out here too. It's like I got a civil protective order last year. There was an NPO in place due to
Yeah.
BD assault, and she hadn't finished her deferment on it. And my son was on school, and in front of his entire class and in front of him, she was threatening to cut my lips off with a knife.
Oh dear.
So I called the police and, reported the violation of the NPO. They decided not to arrest her, which led me to test a safe house with the children, and I filed a civil order.
Right.
3 weeks into that order, she violated it multiple times. I had made a report, which resulted in a new NPO, a new case.
Yeah. Well, that's all great
The
evidence for
lawyer
the
I
second
had at the
prong.
time was
Uh-huh.
Michael Allen with
Yeah.
One in Law.
Yeah.
And he decided since there were 2 NPOs in place, he wanted to drop the civil order without prejudice if she didn't have any more reported violations. And then she had more, they just didn't get reported because I was afraid of like flashback and things.
Mhm.
So that just got dismissed on the 6th, and she already re-violated yesterday. She put false charges with CPS and with Animal Protective Services.
Okay.
And so I was at the police station last night trying to report the violations, because it's technically, a third-party contact harassment on
Right.
behalf of a restrained person, but the officer didn't see it as it being a violation.
But if you had that civil protection order, it would have been an immediate arrest.
Right, and
Yeah.
even the animal control person I was talking to, she's like, yeah, this is a violation, and she should have made this report, there's no reason for us to investigate.
Yeah, it's hard.
And like my sister's hopefully she won't be ex-wife, she called CPS on me twice.
Yeah, and
She called
what's
Fountain
funny
PD
about,
on me, and when Fountain PD says, child's 10 years old, child knows what to do in case of an emergency, there's an adult that's not far away that could be here within a minute, like, she's fine. She decided to go to CPS and called them twice on me.
and sometimes,
They came here.
sometimes
Yeah,
the
I've
person who CPS was called on will get those, because you can get any CPS records that have to do with yourself or your kids from the Office of Guardian of the Dogs. You just go in with your ID and get them all. And so sometimes the person who was the person they were calling about gets those to bring to the court to say like, look how much they're just harassing me. Because like, when they're all like unfounded after unfounded after unfounded, like that's really not credible allegations. So a lot of times, maybe like a CPS worker or DHS worker will be a witness in one of these protection order cases to kind of talk about the status of that. But, yeah. Well, I have time, I don't want to keep you guys here longer than you need to be. But orders all the time, and usually we can at least give some advice. We can help with protection orders much more often than we can with custody and divorce cases, because those take